I'll call the meeting of the Rules Committee to order and ask Attorney Del Campo if he would please read the roll so we know who we have.
Yes, Your Honor. Justice McDonald's here, Judge Chaplin, Judge Farley,
Here.
Judge Hernandez, Judge Chaplin,
Here.
Judge McLaughlin,
Here.
Judge Nguyen O'Dowd,
Here.
Judge Pearson,
Here.
Judge Prats,
Here.
Judge Stewart.
Here.
That's it, Your Honor. You have a quorum.
Great, thank you very much. It's good to see everyone. I think, if I'm not mistaken, Attorney Del Campo, this is our last regular meeting before the public hearing in May. Is that correct?
Yes, Your Honor. No April meeting. The next meeting will be May 8th. It's a public hearing first at 10 a.m., followed immediately by the Rules Committee meeting.
Thank you. Okay, the first item on the agenda is the approval of the minutes from the February 6th, 2023 meeting. Is there a motion to approve those minutes?
So moved.
It's been moved. Is there a second?
Second.
Seconded by Judge Stewart. Any additions or changes to those meeting minutes? If not, all in favor, just raise your hand. That passes unanimously. The next item is 2021-023, proposal to amend practice book section 7-10 and 7-11 regarding retention and destruction of summary process records. Attorney Del Campo, I understand we have two pieces of new information in this package. Is that correct?
Yes, Your Honor. This was last on the agenda in February. You asked that Attorney Shea put together an update on legislation or on the legislative proposals in this area for the committee. Attorney Podolsky has submitted two updates, actually, and I believe both Attorneys Shea and Podolsky are here today to explain them.
Sure. Attorney Shea and Attorney Podolsky, you're there. Okay. Attorney Shea, how are you?
Good afternoon, Your Honor. I'm well, thank you. Rafi, would you want to update the committee?
You're muted. Rafi, you're muted.
I'm sorry. Okay. Would you like me to summarize what was in the letters I sent?
I assume everybody has had an opportunity to review the materials ahead of time. One thing I wanted to ask you is, have you gotten any indication if this legislation is going to be referred to other committees in the General Assembly?
I have no information on that. I don't know that there's any plan to refer it to other committees, but I don't know that there's not a plan. And I'm also not in a position to predict whether it's ultimately going to pass or not pass. I basically don't know. It's the bill in question is an omnibus bill that covers a lot of different programs. This is one piece of that bill, and I don't know how that is going to play out in terms of how the legislature decides what to do with the bill procedurally.
Obviously, it's up to the members of the committee if they want to talk about this further. Normally, in a situation such as this, which is probably more policy driven, we would normally try to amend our rules to conform with what the legislature has done if they do anything. Do you see any reason why we would not follow that process in this instance?
I'm sorry, are you asking me? Or?
Yes, I was. Sorry.
Well, in some sense, the legislature's, the Housing Committee put two different proposals together into the same bill. They're not 100% matching each other. There's some thought that the legislature may match the two proposals together. If they did, then probably judicial would want to kind of adjust its rules accordingly. It is possible that the two proposals could both stay in the bill in some form, ideally with the same time deadlines, but they could conceivably end up staying in with different time deadlines because they address the issue in two different ways that are not necessarily incompatible. So it might be that almost I would say that you might want to reserve judgment on whether you should, how you should conform to see what they do. I mean, one of the ways Section 33 basically is really addressed to judicial, while Section 11 and the collateral sections are not really addressed to judicial at all. And so depending on what they did, it might make some difference. I would assume if they anything addressed to judicial, you'd probably want to conform to, if you could.
I mean, since this is our last meeting and the legislature has a couple more months to go, I don't want to, as they say, get ahead of my skis here and do something preemptively that may not be in conformity with what the legislature wants to do. But having said that, let me open it up to members of the committee for any questions for Attorney Shea or Attorney Podolsky, or if you agree with my or disagree with my proposal that we hold off until we see what the legislature wants to do. I'm going to take silence as acquiescence. Is that right? Okay. So I apologize. The way we operate is not really as good as it should be in conjunction with the legislature, because we adopt these rules once a year. This means that if the legislature does something, it's not going to be until a year from now that we would adopt it. But I'd rather be inefficient than swim out of our lane and get ahead of the legislature on this. I hope you understand.
Yes, we do, Justice McDonald, and I will just say that we'll remain hopeful that the legislature will take action this session, that you know better than most, that sometimes the legislature will act and other times for unknowable reasons. It may not, just given the press of business, and Rafi and I might find ourselves back here before this committee again. And I think that you understand that our position is that this is not necessarily a policy matter that must be decided by the legislature, but that it also involves judicial's authority over its own records. So I'll just state that again, and thank you for your attention.
I totally understand that and agree with it. We try very hard to avoid conflicts between branches if we can. It doesn't mean that we're ceding our authority to the legislature. It means we're just trying to work in a collaborative fashion if possible.
Understood. Thank you,
Okay.
Your Honor.
Thank you. Then the next item on our agenda is 2023-001, proposal to amend practice book section 38-8 to expand the cash bail option. Attorney Del Campo, I saw we have some comments from court operations.
Yes, Your Honor. This was last on February. Judge Pavia came and testified before the committee. At that time, you had asked that it be referred to court operations to determine whether or not there were any operational obstacles that might impede implementation of such a proposal. And I did get that off to court operations. Deputy Director Ralph D'Agostine has responded for court operations. So you have that in your package. I think Attorney D'Agostine is also here. If you have any questions of him, he did indicate in the letter that a 1/1/2024 implementation date would be acceptable in terms of court operations implementation of any programmatic or forms changes that would be required. He did also indicate, however, that that's speaking only for court operations and that there might be other entities certainly that might be interested in this, and he wouldn't be able to anticipate whether or not that time frame would be appropriate for them. But he is here if you have any questions.
Mr. D'Agostine is there. You are. Hi. So who else within court operations are you suggesting would need to have their oar in the water here?
It wouldn't be court operations. It's the other, it's the agencies like the Criminal Information Sharing System, law enforcement agencies, the state police, the Department of Corrections, and the Department of Criminal Justice. One agency within the judicial branch, the Court Support Services Division, might be impacted as well. And that's more from a technical perspective. Like I wrote in the packet, in information I sent to Joe, that the impact would be primarily technical for us. We'd have to make some technical changes to our database, which is definitely doable by January 1st. I just want to be able to speak to those other agencies as to what they might, or even if they do something with their technical systems.
Got it. Thank you. Questions from members of the committee? I mean, I'm wondering, we really need to deal, I guess, with the policy component of this. And with a effective date of January 1st of 2024, that seems to be a lot of lead time for anybody to figure out the technological component of this. It's really not, I mean, I never say never, but it's really changing an existing program by adjusting the amounts and the percentage. I would hope that that's not too big of a technological leap, but as Mr. D'Agostino points out, that would now have 3 tracking systems for no presumption, 10% presumption, and 7% presumption. Having said that, I know that the Sentencing Commission had worked very hard on this. As you remember, it's a very elaborate, robust process, and I wouldn't want to unduly delay it if we don't need to. But let's open it up to discussion by members of the committee. Judge Bratz.
Thank you. Since I'm doing criminal almost every day, all day, I think it's a great proposal, and I think that the sooner we get it processed and in place, the better for more people in the community. So I wholeheartedly support it. I like the percentage going down, the 7%. I think it's going to hopefully induce more people to post with the court versus maybe with the bondsman, which, you know, they lose that money, especially when they're larger bonds. So I'm fully supportive of it.
Let me ask a question of Attorney Del Campo, just logistically. I mean, if for whatever reason, if we pass this and it's adopted by the judges and we learn sometime in September or October that there are insurmountable technical problems, is there any way for this committee to delay the implementation beyond January 1st?
That has been done, Your Honor. I can't tell you today how technically the transaction. I know that some rules have been put off for another period of time. I don't know if they were adopted with that caveat or if the chair went back in to get a different decision adopted by the judges. I don't know. I know we have put off the implementation of rules in years past. I don't exactly, I have to research how, you know, what the technicalities of that are.
Thank you. I personally think that people are probably going to be able to adjust their technology to adapt to this, but what do others, do people want to move forward with this today? Okay, I'm going to take that as a yes. I see a couple of nods. Then based on that, is there a motion to approve this proposal?
Judge Pratt, so moved.
Is there a second?
Second.
Judge Wynn.
There's a couple of seconds there. Any discussion? All in favor, please raise your hand. Opposed? That passes unanimously. Thank you very much. The next item then is 2023-002, proposal to amend the MCLE rules. I know that Attorney Wiener's here and Attorney Uri is here. Am I correct in my understanding that you would like this passed for a month so that you can sit down and talk about mutual concerns in the proposal?
That's correct, Your Honor.
Attorney
That's correct.
Uri?
Yes, Attorney Weiners has talked to me about that. And
Okay.
That's fine with us.
Attorney Del Campo, do you have something you'd like to add?
Yes. Yes, Your Honor. I just suggest that, again, there is no April meeting. Or it won't, this will not, if it's passed, it will not get on the public hearing agenda.
Right.
So if it's brought up in some manner at the last meeting and then presented to the judges, it would only be, and adopted, it would only be valid on an interim basis until the next public hearing comes around.
Thank you for that clarification.
Thank you.
Okay, is there any objection to proceeding that way? Seeing no objection, thank you very much both for your time.
Thank you.
Okay, thank you.
Next is 2023-003, proposal to amend practice book sections 38.3, 38.4, and 43.21 to make those rules consistent with the correlating statutes that were recently amended. Attorney Del Campo.
Yes, Your Honor. This is first time being considered. I don't know if this came through Judge Gold. I'm not certain if Judge Gold is on the, at the meeting. Attorney Casaban presented it for Judge Gold, who is one of the attorneys in judicial legal services section. And she concentrates in criminal. She is here if you want, if you have questions of her, or if Judge Gold is here. I don't see that he is here. But these rules, like it was discussed in the memo, are being amended to comply with various legislation.
I am assuming that this has been done correctly. I looked at them, but I don't know. I didn't compare it to the legislation. Did anybody have an opportunity to look at this in any more detail? I'm sorry, did you say Attorney Casabaum is here or no?
I am here.
There she is.
Yes.
Attorney Casabaum, I mean, this looked fairly technical and I guess, are you confident that it's all done properly and we can move forward with it, or should we spend more time with it?
No, I literally took language from the amended statutes and stuck it into the appropriate sections of the practice book rules that correlate to those statutes. So it's just making those rules consistent with the updates to the statutes that they are paired with.
It looked right to me, but did anybody have any other comments or concerns? If not, is there a motion to approve?
Judge Pratt, so moved.
Is there a second?
Judge McLaughlin, I'll second.
Thank you. Is there any discussion? Other than expressing my gratitude to Attorney Casabaum for doing all of this work, I appreciate that.
And Judge Gold, it was
Judge
a joint
Gold.
effort. Yeah.
He's not here to accept his congratulations, so please extend them to for us. All in favor, please raise your hand. Opposed? That passes unanimously. Thank you very much. Next item, I'm sorry, is 2023-004, a proposal to correct citations on the new practice book section. Attorney Del Campo, it looks like we got a cross-reference incorrect.
Yes, Your Honor. Judge Wilson pointed that out to me, that the reference in one of the subsections was incorrect. I did go through it. I checked it with Judges Levine and Gold, who were the co-chairs of the Jury Selection Task Force Subcommittee that wrote this. It was just an error in transcribing the rule along the way, and it should be changed as noted in the memo. The question I had of you was whether or not you viewed this as a technical amendment. We could do that immediately, post some notice of it, or whether you think that it was so substantive that the judges voted that actual subsection and should see it again.
I consider this to be a technical amendment, or even a scrivener's error. But does anybody have a different viewpoint? If not, we can consider this as a technical change.
Yes, Your Honor.
Do we need to do that as a vote nonetheless, as a technical change, or you just take care of that?
I will just take care of that.
Perfect, even better. Okay, the next item is 2023-005, rules that remain suspended based on the declared emergencies. I had asked Attorney Del Campo to put together a list of rules that are somewhat still in suspended animation as a result of the public health emergency and the civil preparedness emergency. The civil preparedness emergency has been terminated by the governor, but the public health emergency, I guess, is still in place. I'm not certain what we can or should do at this moment, but it does seem like we should be at least revisiting the issue to determine whether or not we should be restoring these rules, or some of them or all of them, to the status quo ante, as they say. But I would open that up to members of the committee about if you have any ideas about what we should be doing. Attorney Del Campo.
Just, yes, thank you. Just one additional piece. The Connecticut public health emergency is due to expire June 28th, or at the time that the federal expires. So the federal is due to expire May 11th. So it's likely that May 11th, these will come back in full force, unless the president changes that and the governor changes his. So that's at this point, we're looking to May 11th.
That I misunderstood. I thought we actually had to take affirmative action on unsuspending the rules. You're saying that they would automatically be restored upon the cessation of the public health emergency?
Yes, that's the way they were adopted. That's always been the case. It's just that the emergencies have never been lifted. So that's why these remain. You have a whole battery of rules that have been quote unquote unsuspended, and that's due to the rule that you enacted, which is Rule 1-9C, which allows adjustments. That was adopted on the basis of Justice McDonald's suggestion, and that basically allows, through some gyration, additional adjustments are amended to be made on the time and location requirements of the rules. And that has been used by the CAJs to unsuspend various rules. The only rules that are really in suspended status now are family and criminal. Judge Abrams was very aggressive with unsuspending the civil rules, and the juvenile rules through Judge Conway were basically all unsuspended. The only ones that remain suspended are criminal and family. Those are the ones you have in this list here. So if you do nothing, if the judges do nothing, and everything stays the same as it is today, then as of May 11th, these will come back online.
And that's a great status update then. I guess we don't need to do anything. I misunderstood. I thought we needed to take some type of action to unsuspend them. Is there any question? Are there any questions on that? If not, we'll move on to the next item, which is 2023-006, a proposal to create hybrid files upon request in cases filed on or before 2014, in which the older part of the file would remain in paper and new entries would be online. This came to us from Attorney Zelotes. Is that right, Attorney Del Campo?
Yes, Your Honor. And actually, if you wouldn't mind indulging me for 1 second, it's 2023-06, 07, and 09 on the agenda. These all came from Attorney Zelotes. I believe he is here. These are all first time being considered. So if you'd like to kind of sort of focus on them as a group, that might be efficient.
That way we can let Attorney Zelotes address all three. And I mean, the reality is nothing's going to happen at this meeting with respect to these anyway, because we would have to have the input of court operations and the CAJ for civil and family. But I'll give you a couple of minutes to address these issues, Attorney Zelotes.
Well, thank you, Your Honor. I appreciate your indulging me. And so I do have three proposals. The first is that we create hybrid files, as Your Honor mentioned. I'm a family law practitioner, and for those of judges that don't practice in front of family court, of course, in 2014, we converted to the e-services system. At that point, all future filings would be in the e-services. However, we've still got a number of cases that are still, recurring, as is common with family cases, where we're still using paper files 9 years after the enactment. And unless the court were to convert to hybrid files, it's conceivable, when you consider post-majority education, that family practitioners could still be using paper files through the year 2036. I think that if the court were to amend its procedures to allow attorneys to start e-filing prospectively, not only could we e-file our pleadings, we could e-file our exhibits, all of which would make the court's job significantly easier. It would reduce the strain on the clerk's office when we want to retrieve the contents of the file, and usually it's the more immediate contents that are of more importance to attorneys. And which would then again free up resources, less time pulling files, less time making copies. And I think at this point, it would not be difficult for the limited number of cases that are still in that paper file context. I think the judge benefits, the clerk benefits, and the attorneys also benefit. I think it's something that the court should take up and consider. On the proposal to grant active members of the bar access to family dockets, right now the only attorneys who can access the pleadings or online pleadings in e-services cases are the parties and attorneys who are active in the case. The reason why I think it would be prudent for the court to allow active members of the bar to be able to access those files is because, well, first of all, when a client perspective comes to us, and we're trying to make a determination as to whether to get involved in the case, what's involved, how to quote an appropriate retainer. We naturally want to see what the contents, what's come before, what we're getting into. Right now, the only way that we can do that is to physically go to the courthouse and to go to the Court Service Center, click on it one by one, and email these documents to ourselves, which is incredibly time consuming. There may be other times where we may be involved in a case, but there's an ancillary proceeding like a restraining order, ex parte proceeding that we weren't involved in that we need to access, or prior divorce proceeding that might have been initiated and withdrawn, and then we come into the case. And there are other times when GALs need to be able to access the contents of the file before they get involved in the case so that they can appropriately quote their services. All of this would be a tremendous benefit to the family bar to help us make more efficient decisions, smarter decisions, and would boost efficiency, generally. But at the same point, by only making it available to active members of the bar, we're still maintaining that right balance of privacy so that the party's neighbors and friends and family can't simply log on to the court and access their documents. I think that this would strike the ideal balance, and the courts should consider it. The last proposal that I have is to amend Section Book 13-29 regarding the place of depositions to allow for statewide depositions remotely, remote depositions statewide as of right, unless someone opposes it, in which case the court can determine if there's good cause to resist that. Obviously, one of the logistical challenges we as lawyers have is if we want to take a deposition of a deponent and they're not within 30 miles of our nearest office, then we have to try to secure some alternative location to conduct those depositions. Sometimes those depositions could be very far away. For example, if I had a Stanford case and I had a litigant in Putnam or a witness in Putnam, ultimately the clients bear the cost of the attorneys traveling to and from these physical locations. And now post-COVID, where we're so comfortable with remote, proceedings and remote depositions, at this point, I think it would make sense for the court to now simply say, if you notice a deposition remotely, it can take place anywhere in the state. But if there's a good cause for why it can't be or should not be allowed remotely, then they can apply, and then the court can make that determination on a good faith basis. So for all the reasons, I would ask that, in the process, in the course of things, that the committee consider these proposals. And I appreciate your making this time available for me to address the committee.
Thank you very much. My understanding two pieces of information, I think, is that currently anybody can access the digital family files from the terminals at the courthouses, right?
That's correct.
So it's not a matter of you know, somebody from New London having to travel to Hartford. You go to the New London courthouse and you could access the information from there. Is that still too onerous in your view?
Well, I obviously the public has the right to view the files if they have the wherewithal and the desire to physically go to the courthouse. That's their right. But let's say, for example, in my situation, I'm in Essex, Connecticut. The closest courthouse to me would be Middletown. So that would be about a 30-minute drive, or New London, 30-minute drive. So if I wanted to view a prospective client's file before I made the decision to commit to that case, it would take an hour of my time to drive to the nearest courthouse to then go to the court service center. It would have to be during operating hours, and then I would have to log on and individually download those documents for me to review. Whereas as a member of the bar, if I could review that from my office, then I wouldn't have to travel. And the same would, like I said, would go for other proceedings like ex parte proceedings or prior proceedings that were filed and withdrawn. All of these things would cut down on the amount of time that attorneys have to spend going to the courthouse to review the contents of the file, which they can do. But I think if it's limited to members of the bar, like we do with civil cases, or actually anyone can see the civil case, but I think if we limit the access to the members of the bar, we strike the right balance of saying we're not going to have people looky-loo from their home computers just snooping on the neighbors, but if they really have the desire, then they can go to the courthouse. So I think that it strikes the right balance and boosts efficiency and helps us make smarter decisions as lawyers.
Okay, thank you. So understanding that we would have to refer all three of these proposals to court operations, to Judge Albus for family, to Judge Bellis for civil, and I would imagine to the family section of the CBA and the Academy of Matrimonial Lawyers for their comments. Understanding that that's all going to take a lot of time, are there any prefatory questions from members of the committee for Attorney Zelotes? Judge Prats. You're muted.
Sorry. If I remember correctly, on the e-files and family, the financial affidavits aren't available to members of the public. Is that correct?
No. So the financial affidavits are sealed, even on the e-services.
That's my only concern regarding if attorneys have access through e-service, would give them access to that information, or is that something that automatically, I don't know, like we need to make sure that, I don't think attorneys that are not in the file should be accessing the financial affidavits. And I don't know if that's something that would be part of this program or not.
Well, they actually if the documents are e-filed, when you click on the financial affidavit, there is a warning that comes up that says that these documents are sealed. Okay. And, no attorney should be accessing those documents. Right. That they would, presumptively be able to rely on the client. But at the very least, but that would still be the same if they went to the courthouse. They could still access the financial affidavits by going to the courthouse, were they to disregard that notice as a practical matter, inappropriately. But I think that the benefit is that I would be able to see, for example, if an attorney filed a motion to withdraw, well, what were the reasons given in the pleading before I decide whether I'm going to get involved in the case, or to be able to look at all the motions and objections and rulings. All of that would be extremely valuable to a practitioner when quoting a price and making a decision as to whether or not we're going to get involved. But I agree, I share Your Honor's concern, but I hope that's responsive to your question.
It is. I guess I'm just noting that if we do provide e-service, that it doesn't expand what's presently being done, just facilitate.
That is correct. It would just grant attorneys the same access to information that they could otherwise receive if they physically went to the courthouse. That's all.
All right, thank you.
I was muted. Any other questions or comments? Attorney, Judge Stewart.
Speaking as a former family judge, I am in favor of the first proposal to go to the hybrid files. I do think that it would be good if, in addition to, I don't know how you make this query, but if in addition to asking court operations, if one or two case flow coordinators could be consulted on that. I will tell you, having been in Bridgeport, I can't even tell you how many paper files were lost, and I was frequently, I mean, very frequently dealing with paper files, just a nightmare. So anything we can do to at least going forward be electronic would be a great thing. I would want to think more on the other proposal about allowing lawyers access. Judge Pratt's raised a good point that concerns me also. I don't think we should just rely on, and we should specifically ask court operations how to do this. If there's some way we can keep the financial affidavits and there's certain, or psychologist reports on the children and things of that nature sealed, even if you are a lawyer. You know, like if there's some way we can do some multi-layer access thing. I mean, I don't think it's a big deal if people are looking at memoranda of decisions or orders or the pleadings from their offices. But I get a little squirrely about some of the other things in family, particularly relating to the children and finances, even if you are checking out the file to decide whether you want to get involved or not. So I don't know. I think court operations are the correct people to ask about that, but I think a pointed question ought to be raised as to that proposal. And then finally, I'll just comment that it does seem to me like revising the deposition rule would be a good one for both civil and family.
Judge Farley.
The third one, first of all, I do agree with, what Judge Pratt and Judge Stewart have said. On the third one, which, as Judge Stewart points out, applies not only to family but to civil, it does raise for me a question that whether or not we should be addressing rules changes that ought to be made in light of the fact that we have evolved to use remote proceedings on a routine basis. For example, there's a related rule to 13-29 having to do with when you can introduce a deposition in lieu of a live testimony of a witness. And one of the circumstances when you can do that is when the witness would have to travel more than 30 miles. But now we are able to take testimony remotely. And does that limitation make any sense anymore? But I can only imagine that there are any number of rules that ought to be looked at from the standpoint that we're now doing a lot of remote proceedings and what rules should be changed. I think what is proposed here makes sense, but I guess what I'm saying is there may be a number of other rules that ought to be looked at.
Thank you, Judge Winnow Dowd. You're muted.
I had the same concerns that Judge Pratt and Judge Stewart had raised regarding the family cases. I sat in family for 4 years. And so I know that aside from the financial affidavits, there are a lot of documents that are sealed by the court, medical documents, psychological evaluations. So I would be concerned that if it's an attorney that's reviewing the file to see if they should or want to, file an appearance in the case, I don't think that those documents should be made available if they don't have an appearance in the file.
Thank you. Judge Pearson.
Yes, thank you. Just to follow up on what Judge Farley was saying, I do think there are many issues that the 009 proposal touches on that we do need to address or should think about addressing with respect to remote events. I will just say this, I tend to be a little bit more of a skeptic when it comes to remote proceedings. And just because we can do them doesn't mean that we should, and doesn't mean that it's a better way to go. It's not to say that I am against, in principle, allowing for these sorts of things to occur, but I think it requires some reflection, and should not just be, we have the technology, therefore we should plow ahead and let it just happen because we can do it. I think there are a lot of important questions we have to keep in mind with respect to remote testimony, and whether it's by way of deposition or in a trial setting. So I think all of this, needs to be considered. I will say, for my part, I'm not necessarily wholeheartedly in favor of it, but that's not to say I couldn't be convinced.
Thank you. Judge Chaplin.
Good afternoon. Thank you, everyone, for their comments. I wholeheartedly agree in the tenor of making the adjustments. But my one issue I want to raise is that sometimes when we make these one-off changes, we run into consistency issues. And I know this may be a bigger scope than what we're doing here in the Rules Committee, but perhaps there needs to be a working group to address the issues as they relate to multiple different rule changes and the advent or continued use of these technological updates, and making sure that we're not changing one rule, then spiting the other rule, or somehow being internally inconsistent overall. And making sure that if we do make these changes, that we are able to do so in a seamless fashion, such that we're not having multiple standards for different areas of law or just different courthouses, if you will, based on the technological means available. Thank you.
All very helpful comments. I should point out, if I recall correctly, some of the issues that are addressed in 009 are already contemplated in practice book section 13-30 G that allows for remote proceedings, remote depositions, but they may just need to be tweaked. But to Judge Chaplin's point, tweaking oftentimes results in unanticipated problems. Given the fact that we're not going to take any action today, I think Attorney Del Campo has probably been taking copious notes about everything that's been said. I would ask him to summarize that and provide an update to court operations, to Judge Albus, to Judge Bellis, and for the two that, for the ones that particularly apply to family, to both the family law section of the CBA and the American Academy of Matrimonial Lawyers. And I would ask you to ask Judge Bellis and Judge Albus if they would, if they're interested to lead the charge in the interim to put together kind of the working group that Judge Chaplin was referencing, so that they could come back to us at the beginning of the next court year, and we could see if there's any consensus that's been developed over the intervening 6 months or so.
Okay, Your Honor, I will do that.
Okay, thank you. Attorney Zalotis, thank you for giving us a lot of homework.
My pleasure, Your Honor. Thank you for the time.
All right, thank you. Take care. The next item then is 2023-008, a proposal to amend various practice book sections regarding the pathways process in family matters. I know we got the proposal by Judge Albus with concerns offered by the Academy of Matrimonial Lawyers in the family law section, as well as some more recent comments from Greater Hartford Legal Aid, New Haven Legal Aid, and Connecticut Legal Services. I will confess that I started working my way through all of these materials and did not successfully complete that mission. I don't know if everybody else did, but there seems to be a lot of lingering questions about this proposal anyway. So I don't know how much we're going to be able to accomplish today, but I do see Judge Albus has joined the committee and we'd be happy to have any overview presentation he'd like to share about this proposal.
Thank you, Justice McDonald. And I know I sent a lot of material. I'll try to summarize it here and answer questions that the committee may have. But by way of background, before the pandemic, the Family Division and the Judicial Branch had started to examine the way that we handle family cases in light of some studies that were done, research done by national court groups, and recommendations made by the National Conference of State Court Administrators and Chief Justices of State Courts. And the outcome of those studies and those recommendations was to suggest and recommend strongly that family cases, really like civil cases, should be handled with differential treatment, that cases should be examined early on to determine the appropriate level of court resources that might be needed to address them and to help resolve them, and that cases should be put on an appropriate path for resolution that gives the parties what they need, but doesn't require them to engage in procedures and court appearances that don't really advance their cases or that they don't particularly need for their matter. And we have begun on this road already in prior years through some statutory provisions that allowed for what are called non-adversarial divorces, where parties could file a petition in a relatively simple case, and if they met the requirements, get a divorce decree without ever having to come to court. The next step that we took with the help of the legislature was to provide for waivers of the 90-day waiting period that otherwise applied to family cases, divorces, and legal separation before they could go to judgment. And this was sort of a logical next step, but we undertook to examine it with the help of the National Center for State Courts in a much broader way. And we had progressed to the point in early 2020 where we had a model for bringing parties in early for triage of their case and assessment of their case by family services and a judge, scheduling orders to put them on an appropriate path, and ordering the commencement of services where those were needed. We met with some focus groups of family attorneys and judges, and our plan had been to proceed for the rest of 2020 to reach out to the public and the family bar at large, provide what we had in mind, listen to their input, and make adjustments and changes based on that input. And then, of course, the pandemic struck, and those plans could not move forward. But at the same time, more than ever, we couldn't proceed with the method of handling family cases that we had already, which heavily relied on short calendar, which involved packed courtrooms that just couldn't be done for public health reasons for an extended period of time. So we made the decision during the pandemic to start to implement parts of the process we had worked on, which we call pathways, because in many ways it was more conducive to the remote proceedings that we were able to do. And it wasn't the best way to roll it out. There was inevitably confusion. We didn't have the opportunity for training that we thought we were going to have throughout 2020 before we implemented it, but we needed to do something to address cases as best we could. In early 2021, we did begin a series of regular meetings with members of the family bar, among others, to talk about the process, to get their suggestions. And it developed, as time went on, that one of the biggest deficiencies in the way we were doing it with remote proceedings had to do with motions, temporary motions during a case that required a hearing. We didn't have much available hearing time, the way we were limited to remote proceedings. But once we were able to resume in-person proceedings, and with the input of the bar, for which I thank them, we instituted another new aspect of pathways called the motion dockets, which were a place for judges to assign these temporary motions that needed to be heard sooner than the next regularly scheduled court date. But the overall idea of pathways is to bring parties in early, between 30 and 45 days from the return date in a new action, to have an intensive meeting with family services to triage their case. It's called the resolution plan date, to recommend services to the court. The parties then go before a judge for the issuance of a scheduling order with checkpoints along the way that we call case dates. And those case dates are an opportunity for temporary motions to be heard on a date that's set in advance that the parties know they have, as opposed to the old short calendar method where every new motion resulted in a court date where the parties might have to go to court and lose a good amount of time to be in court on a day with many, many other people where the court probably didn't have time to provide a hearing of any significant length. So the scheduling order would set those case dates, and in some cases would set trial dates well in advance. We developed 3 tracks. Track A are the cases where the parties either reach a full agreement on their first day in court or are very close to it, maybe just need some loose ends to tie up. Track B are the majority of cases where the parties don't have a full agreement, but with some help seem likely to be able to reach a full agreement. And track C are the difficult cases where it looks from the start like the parties will need extensive resources from family services or from a guardian ad litem, including extensive court time. And the schedule is tailored to the track the case is on. We started the motion dockets, which would be for those matters that shouldn't await the next case date, or if it's at the end of the case, shouldn't await the trial date to be heard. And we started those last summer, and the bar group that we've been meeting with has reported that they generally work well. Judges seem to think that they're working well. So we feel like we've addressed that issue, and we have a way of bringing parties in more quickly, but without making them come in on a date when we probably won't have time for them, which used to be the case. In the early part of last fall, the bar group we'd been meeting with consistently, which included representatives of the Connecticut Bar Association, their family law section, the Academy of Matrimonial Lawyers, and a legal aid attorney on the bar side. And on the court side, the branch side included the Chief Justice, the Chief Court Administrator, the Deputy Chief Court Administrator, and myself. We have been meeting regularly to try to see how we could improve the system, but then we turned our attention to drafting rules. We produced an original draft of rules that we presented to the bar group in mid-September of last year. We met with them later in September. They had some preliminary comments that we addressed with some changes in the rules, and returned a revised draft to them in late September. And our plan at that time was to give the bar about a month to meet with their respective constituencies, and then we met with them again at the end of October in the hopes of getting some feedback with a submission to your committee in November to follow. But there was a lot to cover, and the bar group asked for some additional time at that late October meeting, asked if they could follow up with written comments and suggestions, and asked for about a month to do that, which we agreed to because we wanted their input. And our thought was if we get their comments by late November, we'd be able to submit for your December meeting. But as that time approached, they indicated they really would need additional time, significant additional time. And again, we agreed that that would be useful, and asked them to provide their recommendations and suggestions and critiques by February 10th, which on that day they did. We've since then reviewed it. We've made changes in our draft based on many of their recommendations. Other suggestions they made, we did not feel we could incorporate. And I included in what I submitted to the committee, both everything that the bar group sent to us on February 10th and our responses to each of their suggestions. I'm happy to report that with finally having a full year, 2022, where we were mostly able to do things in person and do pathways the way it was intended, the early data is very encouraging. and I cited some of it in my letter to this committee. I won't go through it all, but one that stands out is that in 2022, the family division disposed of 13% more family cases, divorces, legal separations, annulments, custody and visitation matters than we did in the last pre-pandemic year of 2019. So we think we're on the right track. People are required to come to court less frequently, but they come earlier, 30 to 45 days after the return date, as opposed to what was 90 days under our old process. And the self-represented individuals especially, I think, are benefiting greatly from the new process. They were usually bewildered when they came to court for short calendar or any other court date. And now on their first court date, they know in advance it's not going to be a contested matter, that they're going to get information, they're going to get a chance to discuss their case, and the court is going to make a plan of action to help them. So the amendments that I've submitted represent the changes in the practice book that would reflect the practice that we've had under Pathways. I'm sure we will make adjustments as we go along, but at this point, we think it's important to get things embodied in the rules so that everyone has a better way of planning their case, knowing what to expect. So that's a very brief overview. I'd be happy to address any questions the committee might have.
Thank you, Judge Albus. Before we have questions, I did see momentarily the Chief Court Administrator was on camera. I didn't know if she wanted to add anything to this discussion from her new perch. Congratulations in your new position, Judge Pizzuto.
Thank you. Thank you, Justice McDonald. It's really hard to add anything after Judge Albus's not only written submission, but also the comments he just provided with respect to this new, well, I shouldn't say new, actually, as Judge Albus indicated. We started long ago trying to make the process far more user-friendly because, as Judge Albus mentioned, in the family division, more than foreclosure, more than housing, we have self-representing litigants. Something like 23% of the litigants in our custody actions have lawyers, 23% only. And then in our dissolution actions, 29% have lawyers. And we knew long ago from a survey that we did that what litigants complain about most when it comes to the judicial branch is the length of time the case takes and the amount of time spent in court. So we started addressing this long ago by picking out groups of people who we knew could easily dispose of those cases that we identified by way of Wave 90, as well as the non-ad divorce. And then we still had a rather significant population, primarily, mostly all self-represented, who we had to make an easier way for them to get from the beginning to the end of a family process. And differential case management is what Pathways is. People think that's, Pathways is something new and startling. Differential case management has been around a long, long time. And what it does is gives cases and people the resources they need and treats them individually and holistically, as opposed to the Band-Aid approach we had previously with short calendar. Judge Albus, as well as the Chief Justice, the then Chief Court Administrator, me as the deputy, have worked hand in hand with the family lawyers and all of those sections that Judge Albus indicated, and have listened hard to their recommendations. Certainly, Judge Albus and the other family judges have the same experience that the family lawyers have, and getting all of that feedback. We were at this last year with the Rules Committee, and we deferred and continued our conversations with the bar associations, and they've been fruitful. Those meetings have been open conversations, looking at the process holistically, identifying what needs to be done or what should be done. And now we're at a point now in 2023, after 3 years of working on this, where it seems as if we kind of hit our stride, addressed all of the issues that have been raised by the bar, and think that we have a process that really addresses the needs of our users. And those are the people going through these difficult challenges with divorce, who are confronted with a very complex process that we try to simplify by that resolution plan date being very early and comprehensive. Talking to the family as a whole about all the issues that need to be addressed, aligning those issues with the resources that we have, and setting them on a path to resolution. Have there been bumps? Certainly. And I think Judge Albus, with his insights, as well as the family lawyers, have addressed those. And, these rules address all of that. So, of course, the Chief Justice, me now as the Chief Court Administrator, and our prior Chief Court Administrators support the effort and the process. And you should all know, as colleagues of the trial court, Connecticut's really the envy of so many other states around the country, because we have family relations officers who make this process so much different than any other jurisdiction, who meet with families and the judges early on to address the issues in the case. Everyone's watching what's happening in Connecticut as far as this differential case process goes. There's some other locations around the country that are also implementing a differential case management process for family courts as well, but nothing as comprehensively as Connecticut. And even the early statistics shows that it's really helping people to get from point A to point B, from beginning to end, in a far more efficient manner and far more holistically than what we had to offer to those litigants before. So I probably said more than I should. I appreciate Justice McDonald, you giving me the opportunity to address the Rules Committee. We really ask for your thoughtful consideration of the proposal.
Thank you very much, Judge Pizzuto, Judge Albus. I remember when this first came to us, there was a lot of consternation, and I assume a lot of work has gone into it since then. To my knowledge, none of the members of this committee were involved in that process. So I think we may have to do some catching up to find out what has actually happened over the last year or so in that. I've not been able to piece together what was proposed previously versus what is here now. And, in retrospect, it probably would have been better if we had somebody from this committee in those working groups so that they could give us regular updates about what was going on. So I'm very thankful for the work that's been put in, but I'm not ready to do anything today without pawing my way through some of this in more detail. But I would certainly open it up to members of the committee to see if they've had enough time to review these materials. Judge Stewart.
Well, I would just comment there are at least 3 of us on this call right now who were sitting in family. None of us are sitting in family right now, but we're sitting in family when this was originally rolled out in 2020. And I read the materials, so I do understand them, but I understand too that the 3 of us are probably somewhat ahead of the rest of you. But I just wanted you to know that you do have that resource on the committee.
Thank you. Other comments from members of the committee? I know that, I'm sorry, Attorney Del Campo, is that your hand up or is that from no, it's down now.
No, that is my hand up, Your Honor. I just wanted to let the committee know that Attorney McNamara is at the meeting. She's the representative of the CBA Family Law Section. I don't know if you have a representative here from the various legal aid associations, but Attorney McNamara is here. That section did ask to be allowed to come and speak if you had questions of them.
I appreciate you bringing that to my attention. We always, the CBA are big partners of this committee, helping us work through issues. So I'm happy to have any comments from Attorney McNamara if she's on.
Good afternoon, Your Honor.
Good afternoon.
Would you like me to proceed?
You can, please.
Thank you. Good afternoon to the committee. My name is Attorney Amy McNamara. I have been part of the small group that has met on occasion with the branch since close to its inception. I was asked to appear today as the representative of the Connecticut Bar Association because our current chair, Attorney Case, is unavailable due to a pre-scheduled travel commitment. By way of brief background, I practice exclusively in the area of family law and have for the duration of my career. I also teach advanced family law practice as an adjunct at Quinnipiac University as a passion project at the School of Law. I was the chair. I had the misfortune, I think, of being the chair of the family law section of the CBA at the onset of the pandemic, and I served a second term at the request of my section. During that period of time, I had the privilege to work very closely with the branch, including the branch underneath Judge Bizzuto and Judge Carroll's leadership. And I currently serve as the co-chair for the Pandemic Recovery Future of Court Technology Committee, which is an overarching committee for the Connecticut Bar Association. The first and most important thing that I am tasked to do today, and it is my pleasure to do, is to thank the committee for permitting our participation in this event. Equally importantly, I'd like to express our continued and deep appreciation for the partnership of the now Chief Justice, Judge Bizzuto, Judge Carroll, the Chief Justice, and the Chief Administrative Judge of the Family Division, Judge Albus, with whom I was in very close contact during the early stages of the pandemic. Committee members, what the Connecticut Bar Association would like you to know is that it is not hyperbole to say that the decisions made by this committee will literally change the shape of the experiences of future generations of litigants and lawyers. And when we look at the lifespan of judicial methodology, we have to look no further than the now dead short calendar, which shaped my generation and the generations before mine. So to a group of my constituents, to all of my constituents who have a deep appreciation and respect for the people we serve, the people we see in court, the court itself, the process, and generally the rule of law, the stakes are extraordinarily high. And therefore, in particular, what the chair of the committee said, which is that this needs to be taken thoughtfully, as Judge Albus and Judge Bizzuto have done, that is very much appreciated. The CBA is not guided by metrics. We have no comment on the increased disposition rates other than that's wonderful. And we presume it is as a result of, the horrible consequences of the pandemic, as well as the efficacies of the Pathways Project. Our experience is guided by real world life. We live with these rules daily. And here it is important for me to share with the committee that the membership of the Connecticut Bar Association, as you may or may not recall, depending if you were members, is diverse. Our membership and our leadership touches all corners of the state, and the experiences that we've shared with the branch are not limited to one jurisdiction or one courthouse. And importantly, for this committee to understand, the comments provided by, we'll call them the combined bar efforts, that's the CBA, the American Academy of Matrimonial Lawyers, and the combined efforts of legal aid. This is a very diverse group of practitioners. We're not only litigators, we're mediators, we're limited appearance counsel, consulting counsel, review counsel, collaborative lawyers. So while it's of course natural to believe that the rules are designated only for those who are litigators, our collective experience is much more varied. So with that in mind, I would respectfully, on behalf of the CBA, invite the committee to review our February 10th, 2023 letter and the addendums that were offered. There was a note in Judge Albus's materials that there may be some uncertainty about the authorship of the changes, and we apologize for any confusion. We can certainly indicate what changes are ours and what changes were the branch's prior. We'd also like to extend an open invitation to the committee to review any of the prior correspondence that we'd exchanged, if that would be helpful to your task. I can share firsthand that the topic of pathways and the rule reform has been the almost singular focus of these bar associations and interest groups since March of 2020. And I think you'll see, and I hope our partners at the branch would agree, that we have had a progression of concepts and ideals and that we're all moving towards the same goal. Substantively, I would share with this esteemed committee that it is our hope at the CBA that litigants, regardless of whether they are self-represented or represented by counsel in any capacity, can open the Connecticut practice book and understand how to raise a family law issue to the court and how to have it addressed either by way of the very successful triage family relations offerings or by adjudication with the court. Specifically, they need to know when they are likely to next see a judge as a matter of right and not a matter of review. We are extremely grateful to the committee, we're extremely grateful to the branch for taking in a very good number of our suggestions in their most recent submission to the committee. However, it is the continued position of the bar that certain aspects of the system as currently configured do not provide sufficient predictability to all of the stakeholders. And by way of the most notable example, I would invite the committee to the combined review of the letter and our Schedule A changes as they pertain to Practice Book 2534 and 2550. Our overarching concern has been and continues to be the real world impact of the system. We acknowledge and appreciate and thank the branch for the unbelievable job they did rolling out pathways under a quite literally unforeseen circumstance. The motion docket and case management system, as amended, has been vastly improved, but as evidenced in our letter, the combined bar groups do believe that additional modifications are critical to the success of the program. We want this new system to succeed. We want pathways to be the envy of the country in terms of family law adjudication. But we also know that once these rules are made, they will not be changed in any reasonable amount of time. These will be generational changes, and we are very eager, desperate even, to work with whoever we can to make sure that the changes that are made are right. We thank the branch extremely profusely for letting us have this opportunity. And on behalf of the Bar Association, I'd like to say that we're readily available to assist in any way we can. We remain solution-oriented and constructive, and we are solely focused on creating the best possible pathway system for all stakeholders, represented and unrepresented alike.
Thank you very much, Attorney McNamara. I'll open it up to members of the committee for questions for Judge Albas, Judge Pizzuto, or Attorney McNamara, if you have any at this time. I mean, there seems to be a lot of material to process here, and I don't know, let me ask, am I the only one who's not fully processed all of the information? Okay. I frankly, Judge McLaughlin.
Thank you, Justice McDonald. I just had a question, and I apologize, Judge Albas, because maybe I missed it. I just had two questions. One is if you've had formal feedback from the family judges in the state with respect to any concerns they have, and what they see as, I think Attorney McNamara indicated, sort of the on the ground, I'll say, implementation of pathways. And then my second question is there any other state that is doing something even close to similar to what we're doing here in Connecticut as far as pathways? So those were just my two questions.
Thank you. As to the first question, the feedback from judges, once we were able to start doing things largely in person, the way Pathways was intended, and the biggest obstacle to being limited to remote was the resolution plan date, because the plan and idea always had been that the parties would meet with family services and then go into court, appear before a judge, get their scheduling order. The judge could find out if there was some pressing issue that needed to be heard right away, regardless of what the overall scheduling order was, and to address issues like that. That was very difficult to do remotely when family services personnel were having one remote session with the litigants while judges were on the bench doing remote hearings on other matters. But with the ability to do things in person, judges, the feedback I've gotten has been positive, that it's working, that it's going smoothly. And even and especially the judges, the presiding judges of the larger courts have indicated that it's going well. So the feedback has been good. And people are becoming more acclimated to it. It's been a learning process for all of us. And I only expect that it will get better as time goes on, even than it's been already. But the feedback has been good. As to the second question, I don't know of any other state that is doing this on a statewide basis. I, at last conversation with the National Center for State Courts, there were, if I'm remembering correctly, about 11 or 12 individual jurisdictions that were doing it. Other states, unlike Connecticut, as you know, have strong county systems where the courts in one county may operate very differently from the courts in another. I think that's one of the things that positions Connecticut to do this on a broader basis. And I view that as a positive, that we've been able to do something on a statewide basis with our centralized courts. And as Judge Bizzuto pointed out, with the help of Family Services, and they got special training above all the other training they already had to do these resolution plan dates, to triage these cases. I don't know of any other state that has that resource. So the answer is no, I don't know of any other full state that has done it. But I think we have reasons we can do it when others can't.
Other questions, Judge Stewart?
My question is for Attorney McNamara. So you referenced in your speech today, Section 2534, which is the short calendar rule, and 2550, which is, I think, the case management date rule. Can you succinctly tell us, even after the branch has put in a motion calendar, what it is that the bar dislikes, if you will, about the proposed rules? In other words, why is the motion calendar combined with the case date concept not enough?
I can try to succinctly summarize, and I will be brief. I'll err on the side of brevity and follow up if I'm so requested by the committee. Your Honor, with respect to the Section 25-34, which was in fact previously short calendar and is now just motions, it'll be our motion docket provision. The primary concern with the motion docket, which has been extremely helpful, I think that's important for the committee to know. That was a suggestion that we had talked about very early in the proceedings, like 2020, and the branch adopted. The current iteration still has as a predicate to getting in front of a judge, a review system. So and Judge Albus could probably explain this more eloquently than I can, but the process of the court reviewing a motion to determine when it should next be heard is an extra step in the process from short calendar, where you simply filed a motion and you, as a matter of right, appeared in front of a court. Judge Albus and Judge Bizzuto are quite correct that didn't mean you got heard, but your face was physically in front of a judge. And as it is perceived by the bar now in the language of those rules, and certainly the committee can review for itself, that there is what we perceive as a review element. I would note as well that that the branch did add criteria after, again, responsive to the conversations that we had, that it would consider. Does that answer your question?
It does. And then with respect to the case management date, what is it about that rule, again, succinctly, that the bar wants that it doesn't feel that it's getting?
So that's a bit more challenging to answer succinctly, but again, I'll err on the side of brevity and say that there's concern for the bar about what a case date is and how it will be applied across the multitude of tracks we have, A, B, and C. For a track A case, it's very clear you don't need a case date. For a track B or a track C case, there is we'll call it a grassroots concern that there is going to be a tremendous amount of over preparation or under preparation for those dates, thereby reducing the efficacy of those dates. In concept, they have a lot to offer, we think, and the branch has been very receptive to our commentary on that, but there are still some lingering concerns. It's hard to go into it without being lengthy, and I want to respect the committee's time.
Okay, appreciate that.
Judge Albus.
Thank you. I just want to point out that under the proposed rules and under pathways, anyone filing a motion does have the right to a hearing. Our proposed section 25-34B says that any pendente lite motion is deemed automatically scheduled for the next case date, or if there are no more case dates for the time of trial. So it's not a question of anyone getting the right to go before a judge. The motion docket is for those cases where the moving party believes that waiting until that next date is too long. And we have a very simple case flow request form that we've developed where a party or attorney can check a box saying, I would like this motion added to the motion docket. The next event is not until blank. Here's why, in a couple of sentences, I believe it needs to be heard sooner. And that goes to the presiding judge. And judges have been urged to be liberal in placing matters on the motion docket. I believe they have been. That's one reason they've been working so well. But ultimately, it's the court's docket, and I think it's our responsibility to manage it. And there are times where a request is made, and perhaps the next previously scheduled court event that the parties were told about a month or two ago and have planned for isn't that far away. And it makes sense to wait until then. But I want to dispel the notion that a judge decides whether someone gets a hearing on a motion. They are entitled to a hearing. And it's a question of when the hearing will be. It's automatically deemed scheduled unless the judge, upon request, schedules it sooner. I also want to note that as to the case dates, we recognize the concern that the bar raised about wanting more certainty as to what would happen on a case date, which is designed intentionally to be a date where any number of things might happen, whatever the case needs at that time. And we've added a provision that says that if you have a pending pendente lite motion that you wish to pursue at the case date, you need to notify the other party at least 5 business days in advance. And if you have more than one pending, you have to indicate your priority. So there shouldn't be any more surprise at a case date than there was at short calendar. But in contrast, at a case date, we should have more time to hear those motions that need to be pursued.
Judge Albus, let me ask you, it's been, I don't know, a year and a half since I really immersed myself in these issues. Who set, was under the previous iteration, wasn't a family relations staff person responsible for establishing the case dates? Was that correct?
No, it was always, the family services has always just made recommendations. I think it may have been perceived by some practitioners that that's what was happening. And I can understand why, because of what I said earlier, when they were being done remotely, it wasn't always possible for the parties in council to go immediately before a judge. So family services would make recommendations as to what services should be provided to the case and what track it should be on. But even when the parties couldn't meet directly with the judge, a judge would take a memorandum from family services, decide whether the recommendation was appropriate based on reviewing the information, and the judge would, among other things, set the case dates. But it was always a court order as to what the case dates were and what services, if any, were to be offered and what track the case would go on.
And what would happen if there was, I mean, my recollection is that the case date could be months into the future. What happens if there's something that at least one litigant considers to be an emergency type of motion? Do they still have to wait for that case date months in the future?
No, the first case date would typically be 30 to 60 days from the resolution plan date. If a litigant had a motion that they felt should be heard sooner, they could tell the judge at the resolution plan date, and the judge could order right then that it be placed on a motion docket. If it comes up later, they can file this case flow request, say my case date is not for 45 days. I'm getting no child support from the other parent. I have a motion for temporary child support. I'd like it placed on the motion docket.
Okay, thank you. I see Attorney McNamara, did you have something else you wanted to add? Understanding this is not going to be a back and forth on point to point. We really have a lot of work to do still on this, but I'll let you address whatever you wanted to say.
Absolutely, Your Honor. As I had anticipated, Judge Albus was able to speak more elegantly than I was. The bar does not contest the concept that the pathway system does provide a hearing on either the case date or the trial, and we do have the ability to file a case flow request. The concern is that exactly what you just articulated, Your Honor, which is if the case date is months away, which generally speaking, the bar has found the branch to be receptive to. The greater concern is what happens when the case date passed and the next scheduled event is trial. The bar had made some commentary in our materials that I think says what we need to say.
Okay. Any other questions or comments from members of the committee? Judge Albus, what I would ask is, though we won't be taking any action at it on our May meeting, I will commit to having mastered as best I can these materials before the May meeting. And I'd ask that you join us at that meeting so that maybe we can be a little bit more, or at least I'll speak only for myself, so that I can be more targeted in having precise questions for you about this program. I know you have spent an inordinate amount of time on this, and I'm just asking you for your indulgence as the rest of us try to bring ourselves up to speed with all the work that has been accomplished by you and other members of the branch. Okay?
Yes, I'd be happy to come to that meeting. I appreciate the attention of the committee and the time, and I know you didn't receive this very long before this meeting, so certainly the request is understandable. I thank you.
Donald, I wonder if I could inject something briefly before you move on to another subject. My hand has been up for a while.
Very briefly, Rafi.
I just want to make sure you know the concern of the legal services programs has been primarily, I believe, about pendente lite issues and the difficulty of getting a quick hearing. Probably most of our entire caseload is in a kind of the emergency situation where the person may have no support, no alimony, may need access to a car, may need a custody order on an interim basis. And the concern has been expressed by many of our people that this system is that piece of the pathway system is making it very difficult to get those matters heard early in the process. I would let it go at that. There are two other people from legal services who are here, but I'm not asking you to take this up now. But I just would like it to be called to your attention that it's a very real concern.
And I should, now that there's been extended, let me say, in addition to Judge Albus, I'd appreciate that Attorney McNamara and legal services also be available at the May meeting in case members of the committee have questions. Okay?
Thank you.
All right. Thank you very much.
Thank you.
Okay, so then the next item is 2023-010, a proposal to amend Chapter 21 of the practice book concerning receivers in light of the Uniform Commercial Real Estate Receivership Act. Attorney Del Campo, please explain this to me.
Yes, Your Honor. This, well, as it's indicated in Attorney D'Adamo's memo, this is a public act that was first enacted in 2021. It had an original implementation date of July 1st, 2022. That was moved till July 1st, 2023. Long story is that a formal proposal has never come to the Rules Committee. Judicial has not made a proposal to change the rules. There are rules in Chapter 21 which affect these kinds of receiverships. There is no formal proposal on the table, although I understand through Judge Bellis that the CBA is willing to and will take up the issue and will look to making a formal proposal, bringing a formal proposal to the Rules Committee. But what my office was concerned about at this point was that there are rules on receivers that may conflict with this. We wanted to give the practitioners the ability to understand that you at least thought about that. And we created this new rule, which basically says, and we have precedents for this in the practice book, except as otherwise provided by law, and we name some of those laws. I mean, that happens in the ceiling provisions, that happens in various provisions when you say, hey, you know, there are other rules on this topic, so you have to kind of sort of figure out which ones apply in your situation. We wanted to at least have that kind of sort of provision in chapter savings clause, kind of in chapter 21, to allow the practitioners to know that we realize that this uniform law is out there, and if it applies, fine. We just didn't want people to kind of guess. They could at least know that you talked about it and knew of it.
So, for lack of a better term, this would be a stopgap rule until something more formal gets before us from the CBA.
Yes, I mean, it could be a forever rule, Your Honor, honestly, but it probably will be a stopgap, because I suspect that Attorney Karen will be enlisted and the CBA, and something will probably come forward. I mean, Judicial has looked at it. We actually did ask for more time to look at it, and which is one of the reasons I think that it was pushed forward. But it was determined that it's not the type of rule that Judicial would propose, but that might comment on it ultimately, but doesn't concern operations at this point. So there is no formal proposal on the table from the branch.
Okay. Are there any questions from members of the committee? If Judge Stewart.
So, Attorney Del Campo, are we comfortable? I mean, this seems to exempt these particular type of, rent receiverships and so on out from underneath the rules, which, we do see a fair amount of. So is there something forthcoming from the bar that we would then plug in that works with this new statute that I'll confess I didn't read? It just seems weird to not have some kind of rules for those receiverships, which, they'll come in front of like the water companies and the utility companies and so on. They'll show up here with 20 to 30 of those things. And sometimes money is getting deposited and so on. It just seems a little odd to only rely on a statute.
Well, the except as otherwise provided language, I mean, if any of the rules in chapter 21 apply, they are usable in these situations. If they don't, then you would have to fall back on the statute. I mean, the fact of the reality of the situation is you have a statute and you have a group of rules that are on some of the same topics, and the practitioners are perhaps not going to know which ones to use if they overlap or if they don't overlap. So this is an effort to at least tell them, if there are other laws that apply, then you should use them. If not, then you can rely on these if they assist you. I mean, it's not, I guess it's not at this point perfect, perhaps. There might find a gap, but it was at least intended to recognize the new statute and to allow a practitioner to use it as they felt appropriate. So there may be some gaps. I don't know. We've tried to adjust that in the memo, I think. But this is as opposed to having nothing. I will say, because your meeting is in May, certainly the CBA or whomever else would want to come forth, if you do choose to move this to public hearing, there's another couple of months that the CBA could, come to the public hearing and address the issues, and perhaps with a proposal. I don't know that. This at least gets it in front of you and at least hits head on the issue. It's just that no group has come forward yet with a formal proposal to renovate, a dozen rules or so.
So Attorney Del Campo, I'm sorry, Judge Stewart, did you have any follow-up questions?
No, I don't. Thank you.
I mean, this may not be our typical practice, but tell me if there's anything that would prohibit us from adopting this kind of generic language and having a sunset provision a year from now to encourage the CBA to get us a proposal in that 1 year window. Do you see any problem with that?
No, I guess you could do that. You could just, you could write a sunset provision in here, I guess, and then you would have to, the judges would adopt it for a specific period of time. And we did that on the interim rules, on the emergency rules. There were some rules that were effective only for a certain period of time, and then they sunset.
What do people think about that concept? There's just overwhelming enthusiasm among the committee. Any thoughts about how to proceed, folks?
Well, I don't see a problem with the concept of doing this. I think it makes sense, and there's really not any substance to it, other than just alerting people to the fact that, you know, the statute is out there. And, you know, we can put a sunset on it. I'm not sure that's going to move the CBA any more quickly. We may have to extend it, but I don't see any problem with that either.
Would people feel comfortable with a 1-year sunset provision from the time that it takes effect? Okay. I'm taking nods as affirmation. Attorney Del Campo, I'm sorry, it would become effective on July 31st? What? No.
It would probably become effective as on publication, since this goes into effect July 1st. If you deem it appropriate, you would recommend to the judges that they adopt it upon promulgation, which is publication in the Law Journal. So it would be effective probably around July 15th.
Okay, and so why don't we add in sunset provision for 1 year from the date of adoption?
Okay.
By the judges of the Superior Court. With that understanding, is there a motion to approve?
So moved, Judge Pearson.
Is there a second?
Judge Prats, a second.
Thank you very much. Is there any further discussion? If not, all in favor, please raise your hand. That passes unanimously. I believe that is the last item on our agenda, unless Attorney Del Campo tells us we have anything else we need to address today.
No, Your Honor, we have nothing else.
They'll be happy to be done with us today. All right, thank you, everybody. Is there a motion to adjourn?
Oh my, Judge Prats, so moved.
Is there a second? I'll second it. All in favor, say aye or raise your hand. We stand adjourned. Thanks, everybody. Have a great afternoon.